So mobile homes are registered two different ways. If the mobile home is registered through the Department of Housing, it does not need to go through probate. If the mobile home actually has a deed, it would need to go through probate. And I don't know why they register them two different ways, but they do. So you always want to check. Hold on one second. And I will just tell you, if they only have a mobile home, run, because it will take you forever to get that thing transferred. Yes, question.
Aircraft.
I have not had to deal with too many aircrafts, and the ones that I actually have had to go through probate, but I don't actually know if we just had an aircraft, if it would or not. I would check the code in the exclusion. It was not specifically listed, but I suspect it depends on how it's registered. And if it's similar to the way vehicles are registered at the DMV, then it may not, but I'm not 100% sure on that. So important dates to note in probate. So one of the things that I really like about probate is it's statute driven. So here in this office, we have probably 10 or 15 copies of the probate code. There are many, many sections that deal with probate, and I've given you a lot of the code sections in the handout. But generally, there are very clear rules for probate, which is why I like them. So the 15 days. So probate, the period, notice period for probates is 15 days, which is relatively short, which is great. Does that mean that you can get a court hearing in 15 days? Absolutely not. But theoretically, the notice period is only 15 days. That counts for noticing your probate. So you only need to give 15 days notice when you're doing an administration. It counts for the publishing. You have to publish your notice of administration at least 15 days before the hearing for your probate. And it counts for a NOPA, which is short for notice of proposed action. So there are times when you have to serve a notice of proposed action in a probate, which we will get into in a little bit, and that is only 15 days. There is also a notice, skipping ahead, giving you a preview for next week. There is a notice period for trust administration as well. So you can send a notice of proposed action in a trust, but that is 45 days notice. So big difference there. So then we get on to 30 days notice. What requires 30 days notice? So if you are the holder of an original will and somebody passes away and you know that they have died, you are supposed to lodge that will with the Superior Court in the county in which they were domiciled or lived within 30 days. If you are the executor of that will and you fail to do that, you could waive your right to serve as executor. Now, there are no probate police per se that are going to come to your house and say, we know you have that will and you didn't lodge it. But if it goes on for a long period, the argument really can be made that they forfeited their right. If it's 31 days, do they lose their right? Not from a practical matter, but just be aware of that. And where that sometimes comes into play is maybe one child was named as the executor, and just hypothetically, because this really never happens, but just suppose they don't get along well with their brothers and sisters and they failed to act and they thought that they were in charge and didn't have to do a probate, and it went on for a long time. One of their other siblings could make the argument that they held the will, they didn't lodge it, therefore they forfeited their right to be executor, and one of the others of them should serve. Yes, question. It does. So if you come across the will and now it's in your possession, you have a duty to lodge it. And where it even comes into play is with attorneys. So your client comes in and they bring you the original will. Now you are the holder of that original will and you have a duty to lodge it on their behalf. And then a creditor claim. So we will get into how to process creditor claims, but be aware that if you fail to respond to a creditor claim within 30 days, at the creditor's option, they can deem it rejected and they can file suit on it. 90 days. So if you reject a creditor's claim, they have 90 days to file suit, and if they don't, then you are free and clear. 120 days. So the creditors have 120 days from the date letters are issued to file their creditor claims. The inventory and appraisal, which I have shortened to INA here, must be filed within 120 days from letters issuing. And the spousal election, and this still to this day, after 15 years of practicing, trips me up. So I'm going to give you a pro tip here. A spousal election has to be filed within 120 days. If a surviving spouse is probating an estate, even though they are the ones probating, they still have to do a spousal election to have their share of either community property or what they would receive as separate property as part of the administration. If you are an attorney and you are interviewing a client, you want to know that sooner rather than later if that surviving spouse is including her property in there, because it makes a huge difference over what you're going to be paid in that probate estate, and it may or may not make the economics work. So just be aware of that. And then the 1-year statute of limitations is a hard statute of limitations for creditors to file a claim after somebody's death. And I say that that is a hard statute of limitations, meaning if they blow that 1-year deadline, there really isn't a way to get their creditor claim processed and paid for. And they do that for the administration to be timely done. You don't want to leave a probate open for 10 or 20 years or even 5 years and not know what the creditors are. So that's why they have that hard.
I have a quick question.
Yep.
It's just
Yep.
after they notice that 1 year from whatever they were noticed.
It's actually 1 year from date of death. So if for some reason the death was hidden or they didn't know that there was a death, they might be able to extend that, but it really is a pretty hard deadline of 1 year from date of death.
Okay. So
it comes up sometimes that somebody doesn't tell you that somebody, as an attorney, they'll come in and say, oh, you know, my dad died and I really need to get this house cleared. And you're like, oh, when did you die? 2005. Well, they've been living in the house since 2005 and now they need to refinance or do something. So it's just coming out that they need a probate, and that's why there's a delay. And in that case, even if creditors came forward, they most likely are not going to be able to file a claim. So more about non-probate transfers, pay on death accounts. We kind of went over what the exceptions were, joint tenancy, spousal property petitions. So there is a method in California, short of probate, for spouses to collect either their share of the community property or their share of the separate property through a non-probate procedure, which is called a spousal property petition. I want you to be aware of them. We're not going to go over that in too much detail today, but just be aware. And then small estate affidavits. And that is where that 184,500 number came from. It's from the probate code section 13-100, which is the small estate affidavit section that tells you how you complete a small estate affidavit. So if you have, a lot of times people will have trust, but they'll have their regular checking account and they won't have that in the trust. It typically does not have more than $184,000 in it. And you can collect that with a small estate affidavit. There are specific rules in the statute under section 13-100, which tell you have to wait 45 days. You have to supply an original death certificate. It has to be a notarized statement under penalty of perjury. But basically that is a shortened procedure to allow people to collect small accounts and not go through the probate process. What does intestacy mean? So intestacy just means somebody died without a will. So your clients will often come in and say, oh, he didn't have a will, so everything goes to the state, right? No, everything does not go to the state. I don't know exactly where they get that, maybe from the unclaimed property process or something, or maybe from the word intestacy. But no, intestacy does not mean everything goes to the state. For those of you new, go ahead and sign in over there and then grab one each of the handouts. We're going to be going through those in detail. So when somebody dies intestate, that means they did not have a will. So there's no executor named because there is no will. So that is the difference between the term executor and the term administrator. Administrator is for somebody who dies intestate. There is no will, there is no executor. A executor is somebody who was named in the will and serves. Now, there is a term that comes up pretty rarely. I think I've used it twice in my 15 years, but I will tell you what it is because it's baffling. I think it's called administrator with will annexed. And what that means is there's a will. The person who is either no one was named in the will because it was poor drafting, either they did it themselves or the attorney didn't know what they were doing, or the person or persons named to serve are either already deceased or can't serve or don't want to serve. And so another administrator is being appointed for that will, and that is what that means. So it's an administrator with the will. Yes.
Well, we're talking about titles here. That's the title of the person that play into that.
Personal representative is a over-encompassing term. So it would qualify to an executor, it would qualify to an administrator. To some degree, it even qualifies to non-probate stuff. It's just the personal representative of the estate. Please, 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 if you take one thing away from this class, please never call your executor a trustee or your trustee an executor. Trust totally different than estates. Executor implies that there is a probate open and going. Your clients will always tell you, oh, I'm the named executor of the trust. No, you are the trustee of the trust. People really do not, clients do not really fundamentally understand the different estate planning tools. So inevitably they will call your office and say, I'm in charge of the will. Well, a lot of times what they really mean is their trustee. So you really have to probe in those initial conversations to see, are you really talking about a probate here? Or are you more likely talking about a trust administration? So who can serve as administrator? So there is a code section that provides the priority of who can serve. And it starts with surviving spouse. Then it goes to children, then it goes to grandchildren, and then the list goes on and on. So what you sometimes have, again, so rare, but sometimes you have a stepmother who does not get along with her stepchildren, and the father has died. The children will come to you and say, we want to probate our dad's estate. Well, if he had a surviving spouse, she has priority. And if she objects to them serving, they're not going to get to serve. And the reason that is important for you as a practitioner is to know you could do a lot of work and get kicked out right out of the gate. So you really have to probe as to whether or not, if there is a surviving spouse, is she willing to serve? Has she already filed a probate petition and they just don't like it, so they're trying to file a competing one? What is really going on there? Now, what I like to do in those situations when they say, hypothetically, let's just say your client is not completely truthful with you. So what I like to do is say, okay, so there's a surviving spouse. As soon as I get her nomination for you to serve, happy to file your probate petition, because then you know ahead of time if they're really serious about her agreeing to them to serve. If she nominates them, they can absolutely serve. When we talk about nominations, so a lot of times when I have a lot of children and any one of them would have equal priority, I will say, are your brothers and sisters on board with you being the one to serve? Oh, yeah, this is great. Okay, well, let's just get that right out in the open. Let's have them nominate you to serve. It's not as bad if you have competing people in the same priority, unless there's really something terrible that you don't know about your client, like, you know, they killed the decedent because now they can no longer serve. But otherwise, you're kind of on equal footing, and the person who makes the best argument, and a lot of times the person who even files first is going to get it. The other thing to watch out for is if your client can't be bonded and somebody else can. When you're talking about equal priority, the person who can be bonded is more likely to get appointed.
Question.
Yes.
Once the surviving spouse, if they do nominate one child, can they revoke that nomination?
Not, no, they cannot revoke the nomination. They could potentially file something later that changes their mind to try to have the person removed if they don't act in accordance with the probate code. But no, they, well, I shouldn't say that. Very few things in the law are never and always. So, they could revoke it if you haven't filed yet. So let's say they sent you the nomination and then they call you the next morning and they say, you know what, I changed my mind, I slept on it, I think they're a terrible person, and they send you something that says they revoke it. That would be an appropriate revocation. But once you've already filed the petition, you filed the document, I don't think that it's reasonable for them to just be able to submit a revocation. But yes, if it was fairly close in time, I would count that and I would file it. Sometimes, super unfortunate, children die before their parents. If they are not married and they don't have children, then their parents are in line to serve. And if for some reason their parents don't want to, or they just don't feel like they're up to it, then their brothers and sisters have the priority to serve. It rarely really goes deeper than that. Most people have some family that will serve, although occasionally you will find an elderly person that they were the last in their line and there isn't anybody. And in that case, pretty much anybody can serve, any relative can serve, or they can nominate a professional to serve, or in some circumstances, even the public administrator will step in and serve. But those people are way down on the list. Okay, so then who inherits when somebody dies intestate? It's pretty easy when you have a will because the person spells out who gets what. But when they don't, then it goes again by the probate code and the laws of intestacy. So community property goes 100% to the surviving spouse. Something to be aware of in California is on real property. There are two ways to list community property, and the results on death are very different. So if you have community property with right of survivorship, that acts as a joint tenancy and it passes to the surviving spouse outside of probate by operation of law. You file an affidavit of death of joint tenant and surviving spouse goes on her way. If it merely says community property, then that is treated as a tenant in common, meaning husband owned one half, wife owned one half, and it doesn't pass by operation of law. So in those circumstances, you either need a spousal property petition or a probate. Okay, so separate property. So if there are no children, parent, brother, sister, or issue of deceased brother and sister, so nieces and nephews, then the surviving spouse gets it all. If there is one child, then surviving spouse gets half, and the child gets the other half, or the parent, brother, sister, or niece or nephew. If there are two or more children, then the surviving spouse gets 1/3, and two or more children split the other 2/3. And if you have a child that predeceased, then their issue, meaning their children or grandchildren of the decedent, take that parent share and split it amongst themselves. So when you're doing a probate intake, what are some of the things that you need to ask? Number one, the date of death. Date of death is going to tell you a lot and potentially raise some red flags. Again, if the person died 10 years ago, there's a red flag there. If they died yesterday, that's potentially another red flag of, let's get them in the ground first and then talk about how we deal with their assets. Where were they living at the time they died? And a lot of times people don't die where they live. So keep an eye on the death certificate. You really want to know where they lived, especially here in Contra Costa County. We have so many counties so close by. Maybe they were taken to a hospital in Solano County and died in Solano, but they actually lived here. You are going to file that probate where they lived, not where they died. Was there any estate planning documents? Did they have a will? Did they have a trust? Were they married? So I will tell you that there is no common law marriage in California. It doesn't matter how long you cohabitated with somebody that you were not legally married to or a registered domestic partner. You are not their spouse for any purposes whatsoever. There is also no common law divorce. So a lot of times the kids will tell you, oh, they lived apart, they were basically divorced, she's not getting anything. No, if they were legally married, surviving spouse is going to be entitled to something, and probably a lot more than what they are anticipating. Did the person have children? If so, are the children adults or are they minors? And the reason this is important is because if they're minors, most likely a guardianship is going to need to be open for those minors. Or at the very least, you're going to need to seek the appointment of a guardian ad litem to represent those minors' interests in order for you to effectively administer this estate. Something I didn't put on here that I am realizing now is, do they have any pre-deceased children? Because if they did, if those pre-deceased children had children, those people are going to take in intestacy. So you definitely want to know that. And then if they weren't married and they didn't have any children, living or pre-deceased, then you need to know who their other relatives are. Then you want to know what the assets are. What is the real property? What is the personal property? So just kind of a rule of thumb, because people get hung up on this personal property issue. If it is not real property, it is personal property. If it is a bank account, if it is an IRA, if it is a stock account, that is all personal property, along with the cars, the boats, the furniture in the house, clothes. Not real, it is personal. Yeah.
For domicile, when you have somebody that's living in a retirement home or was living in an extended care home, but still held their house, what do we put down as domicile?
So sometimes it doesn't matter because both are in the same county, in which case doesn't matter. So what I like to do, so there is a presumption. So this part is real. There is a presumption that an elder always desires to return to their home if they can. So you can use their home address if it's more advantageous to where you want to file your probate, or you could take the position that they were domiciled in this care home if that probate county would be a little more advantageous. And when I say advantageous, I would rather poke my eye out than file a probate in San Francisco. So if I had a choice between San Francisco and pretty much any other county, I am going to try to find a way to make it any other county. When we were dealing with COVID, Alameda County is one of the only counties that actually follows the probate code that says a hearing on a probate has to be set within 45 days of when it was filed. that was really handy because we could get stuff moving more quickly. Whereas Contra Costa was setting things out 6 months. That is a long time to wait to get your letters of administration. So if there was a way to get them sooner, we definitely tried to do that. So, like I said, there is a presumption that this elder always wants to return home, but you can kind of work around it a little bit. All right, we are going to start our case study. So we have a fact pattern here. So stepmom visits your office. Her husband, poor planner, died on April 1st. She has tried to get some money from the brokerage account to pay bills, but they are telling her she needs a letter from an attorney. Poor planner was 86 when he died. He had been diagnosed with cancer about a year ago. He was going to have a will done, but he did not get around to it before he died. Stepmom is not worried because he told her several times she gets everything when he dies. He has 2 adult children, adult son and adult daughter. However, he told her he does not want them to have anything. They did not have a good relationship. They never saw him on holidays and didn't even visit him in the hospital. They took their mom's side in the divorce. So the first thing is, she has tried to get some money out of the accounts and the brokerage is shutting her down. You will often have times where, and this happens a lot when you are administering a trust, and your client will come back to you and say, I went to the bank to collect the account and they tell me I need letters. Really? What they're referring to is letters of administration, and they don't. And the banks often give our clients really bad advice. But people hear letters and they think that all they need is to get a letter from the attorney. That is not what they need. They either need letters of administration or they need the attorney to call whoever is telling them that and explain they don't need letters and why they don't need letters. This is actually very common. Honestly, even if he didn't get diagnosed with cancer a year ago, he was 86. What are the chances? Like, he should have had a will or a trust, but he did not. She's not worried because he told her she was getting everything. So this is super common that, and even with trust, people think they understand the law. They've Googled it. They totally get it. And they have a lot of misconceptions about what happens. Your clients will go on and on and on and on and on about why stepmom should not get anything, about why this daughter should not get anything, about why this grandson whose father died should not get anything. None of that is relevant. Doesn't matter. Doesn't matter if they were the worst son in the world, short of if they actually killed the person, in which case they are disinherited under law, or they were convicted of some sort of elder abuse, either physical or financial. That does not eliminate them, but it could reduce what they get. So really, there are very few circumstances under the probate code where somebody is going to be disinherited because they were a bad person, and that's really murder. So short of murder, doesn't really matter how bad of a son you were, how bad of a wife you were, any of that. But they will want to tell you all of that, and take your time with it. Okay. So they were married for 20 years. And they have the following assets. They have $1 million real property in Martinez. Title is in poor planner's name only. There's no mortgage on it. And he got this in the divorce from his first wife. He has a $400,000 IRA account with no beneficiary listed. He has a $20,000 insurance policy for burial. The beneficiary on that is stepmom. The $25,000 joint checking account. And he has a $100,000 savings account in his name only. There are medical bills from Kaiser, American Express, and Home Depot. So I tried to make it not too complicated, but to give you some things to kind of work through, like any good law school exam. So the first thing is they were married for 20 years. So there might be an assumption, oh, 20 years is pretty long marriage. It's probably all community property, but you need to dive a little bit deeper. He's 86. So a 20-year marriage, he was already 66 when they got married. So he might have already been retired. So in California, community property is anything earned during marriage. If he was already retired and not working, then that $400,000 IRA account isn't probably going to be community property because he earned it all before the marriage. The $1 million real property. So again, they're living in the property together. You might assume, oh, it's probably community property. Well, when was it paid off? Because if no community funds used to pay a mortgage on it, then there's no community interest there. And here she tells you he got it in the divorce. He already had that property before they were married. So that is likely separate property. And then the $100,000 savings account in his name only, you would need to dive into a little bit about what the source of those funds were. But for our argument here, we are going to say that they are separate property because they're in his name only. So, yes.
In California, is there a presumption for separate property?
There is. The presumption is anything earned during marriage is community property. Anything by gift or inheritance is separate property unless you commingle it with community funds. But those presumptions can be rebutted. Title is also presumptive. So sometimes we start out with, well, it's only in his name, so it starts out as community, but if it was acquired during marriage with community funds, then we can oftentimes convert it to community. Yes.
Does it change anything if it's purchased before marriage, but then they use community funds to pay it off?
It absolutely does. It does not,
But title
Convert it.
never changes.
it does not convert it to community property, but the surviving spouse has a community interest in that property. So there is a lot of crossover oftentimes between family law and probate decedents estates. So do be aware of that. Also, either spouse can give away their half of the community property. It does not have to go to surviving spouse, but they could only give away their half. So he could have done a will. Let's say this was all community property. He could have done a will and he could have given his half of the community property to his kids. And she still has her half of the community property intact. If there is a divorce pending, then those rules change. So that is something to be aware of. Once you have filed for divorce, the temporary restraining orders go to in effect once the non-filing spouse is served, which restrains them from making changes to the assets until a judgment is entered. So what somebody can do while a divorce is pending is make a will to give away their half of the community property. They technically can make a trust, but it's pointless because they can't fund the trust. So they're allowed to make a will to say, okay, I no longer want this person who is divorcing me to get this. But it gets convoluted because there hasn't been a judgment on what is community and what is separate. So this is just something to be aware of because you will be surprised at how many people actually file for divorce, but they don't actually get around to divorcing. And they just assume that that was enough. And their children assumed that that was enough. And boy, are they mad when they realize that that spouse is taking the lion's share of stuff. Okay, so, yeah.
So when it comes to legal separation, they're living separately and they're moving clear that they have no intent to come back together. It's still not treated as,
Still not treated as a divorce. Nothing severs that marriage except a judgment of divorce. And sometimes you can get your divorce, but the property issues are still reserved and haven't been separated, but that would count as a divorce. But separation not. But what a separation does do is it gives you a point of time where separate property starts moving forward from that point on, and separate debt. So we went over the. Okay, so we are going to initiate our probate. So if you get your sample packet of forms, we are going to go through and complete this. So first of all, where are we going to be filing this probate? Where were they living when he died? Martinez, California. So we're going to be in Contra Costa. Okay, so the forms that we are going to use for probate are the DE 111, which is a petition for probate, the DE 147, duties and liabilities, the DE 150, letters, the DE 140, order, the DE 121, notice of petition to administer estate, and the DE 142, waiver of bond, which is optional. So we're going to start by going through our petition for probate. Okay, so we've already determined that we are going to be in Contra Costa. So how do we complete this petition for probate? So you will notice that the top two boxes say probate of will or probate of lost will. So we don't have a will here. So we know that those boxes are not going to be applicable. What we are asking for is letters of administration because our person died intestate. We haven't gotten into the Independent Administrations Act yet, but we will. I always, as a matter of practice, ask for that independent authority. It provides your client a lot more leeway in what they can do. Now, if your client cannot be bonded for some reason, you are not going to be able to get that. So be aware of that unless there's a waiver of bond. If the beneficiaries or heirs at law are willing to waive bond, then you don't have to worry about it. When you have a will, 9 times out of 10, it waives bond. So then you don't have to worry about a bond, and you would most times, 9 times out of 10, the will authorizes the executor to act under the Independent Administrations Act. So you're always.
Who requires the bond? Who sets that requirement? Is that the beneficiaries?
No, so that is by code. If they don't waive it in an intestate estate, then a bond is filed and it is set by code based on the value of the estate. Okay, so then publication. We talked about this a little bit. 15 days. You have to publish in a local newspaper 15 days before your hearing. So you have an option that the court will do it for you. I have never, ever in my 15 years used that option, and I don't even know if it would work, to be honest. So we always arrange for publication ourselves. So here in Contra Costa County, we choose to use the Contra Costa County News Register most of the time. If your person dies in Alameda, there are several different newspapers that publish to the different sections of Alameda. So don't just assume because it's Alameda County, it's one paper, because Alameda County is so large. Like they died in Oakland, it's one paper. If they died in San Leandro, it's another. So make sure you check in and know that you're publishing it in the right newspaper, because if you don't, your notice fails and you have to start all over. And that is a big bummer. So our petitioner is stepmom, and stepmom is also our client. So then it requests that the decedent's will be admitted. Well, we don't have a will here, so that doesn't apply. And then we go down to administrator and check that box. We are asking for full authority, so we check that box. And we are setting the bond at 1,600, and I think honestly, I made a mistake in my, I was trying to make the numbers work on my final distribution. So, we are going to make a correction to our fact pattern. It is a $500,000 IRA, not a $400,000 IRA. So sorry about that. So that is why we are setting bond at 1,600. So if we're looking at our fact pattern, what is in our probate estate? Well, we've got a real property that's in his name. So we're going to be probating that. We've got a $500,000 IRA account that has no beneficiary, which poor financial advisor who didn't get a beneficiary on that, but it happens. We've got a $20,000 insurance policy. But wait, we have a beneficiary on that. That's stepmom. That's not part of our probate. We have a $25,000 joint checking account. Joint checking account passes to surviving joint tenant. That's not going to be part of our probate. And then we have a $100,000 savings account in his name only. So that will be part of our probate. So that is where we came up with the 1.6 million probate. And that is why we set the bond at 1.6 million. So something to be aware of, even if a will waives bond and your executor is out of state, the court will make you set a minimum bond of at least 20,000 because they don't really have jurisdiction over that person. So they want to make sure that they're protected. So out of state executors will require a bond, no matter if the will waives it or the beneficiaries waive it. All right, so then we go on to when did the decedent die? He died on April 1st in Martinez, California. He was a resident of that county. And then you put in his address of where he lived. And something to be aware of here is it says city and county of decedent's residence. I mean, our natural thing is to do Martinez, California, but it really needs to be Martinez, Contra Costa County. So then you list what the property is. So we have 600,000 of personal property, and this throws people off a lot. Anything that is not real property is personal property. So the IRA and the savings account, personal property. Then we have $1 million of real property. It's not encumbered, so we did not put anything there. So be aware that your statutory fees for being the attorney and the statutory fees for your administrator are set by statute based on the gross value of the estate. So it doesn't matter if there is a $900,000 mortgage on this house, you still get paid on the $1 million. Then we go down to, does the will waive bond where there's no will? Are all the beneficiaries are adults and have they waived bond? Here, they don't like her and she doesn't like them. So they're not going to waive bond. So we didn't even try to do a waiver of bond. So then how did the decedent die? Well, he died intestate. If he had a will, we would have checked a copy of decedent's will dated. If he had codicils, self-proving wills. It gives you the code section right there. Make sure if you have a will that you do review it, because the language is very specific for a self-proving will. Most wills are, but not all are. Some are really old and they don't have the exact language. And if you don't have a self-proving will, then you need to get an affidavit from the witnesses. And you don't want to get to your hearing and realize that you need that, because then you have to go back and once again, you have to start all over. So now we're, excuse me, now we're at appointment of personal representative. So the first section is applying to executors. We don't have an executor because we don't have a will. So we go down to appointment of administrator. Person is entitled to letters, and it says explain the priority in attachment 3G. And I'm realizing I made an error. So if you check the box C and say how they're related and you say surviving spouse, that you will make a correction to your sample so you have it on 2C as in Charlie. So that really explains the priority, but when it gets, hold on one second, when it gets more convoluted, so let's say, we're a few deep, then sometimes you do need to explain that priority, yes.
Yeah, I was gonna say, if you check C and the surviving spouse, you don't need that attachment anymore.
You really don't, because it's so clear. Check, always check your local court rules in Contra Costa. If they can see clearly what the priority is, then it doesn't matter. But if you're appointing somebody who's at a priority, so maybe we have a surviving spouse, but yet it's going to be a kid, then I think you do need to explain a little better. Surviving spouse does not want to serve. Children are next in priority. This is the son. It doesn't have to be a long explanation, but something. And the proposed personal representative, your client, is a resident of California. She's a resident of Contra Costa County, and she's a resident of the United States. So non-residents cannot serve under intestate as an administrator under the intestacy rules. All right, then we are going to section 5 is a tricky section, and you might want to highlight your sample because inevitably people forget to check one of these boxes. And then it's not fatal and you don't generally have to start over, but what you will have to do is do a declaration to the court to correct it before your hearing when you get your tentative ruling. So Decine was survived by, he was survived by a spouse. If there is no spouse, we need to tell him whether he was divorced or never married, or if the spouse was deceased. Did he have a registered domestic partner? No registered domestic partner. He had children. He had natural or adopted children. Did he have issue of a predeceased child? So this is where a lot of people miss it. They don't check 8. He had no issue of a predeceased child. And then was he survived by a stepchild or foster child who would have been adopted? And no, he was not. So people miss that, and they miss the registered domestic partner a lot, so just be aware of that. So here, because we have spouses and children, we do not need to complete 6 or 7, but if you don't have a spouse or children, then you need to go down the list and complete it. And the reason they're asking you about a predeceased spouse is because in intestacy, if he had a predeceased spouse that died not more than either 5 years for personal property or 15 years for real property, then that deceased, that first spouse that died, her heirs are entitled to potentially take under this probate as well. So be aware of that. When you have a trust, so it is sometimes necessary to do a probate, even when you have a trust, because something got left out of the trust. Maybe a Hegstead petition, which we'll go into next week, is not appropriate or unavailable for some reason, and you're doing a probate. So when you do a trust, you will have what's called a pour over will, which means anything that we left out of our trust, pour it over and put it into the trust once you do the probate. So 8 really speaks to that and makes sure that if you're doing that, you don't forget to list all the people named in the trust. That is a very common mistake. And anything to do with notice is fatal. If you do not have 15 days to get your notice out before your hearing, which you rarely do, because by the time you get your tentative ruling, you don't typically have 15 days, or it's right at the 15th day, and it's going to take a little time to put this together. Your notice has failed and you have to start all over. Anything other than notice is typically not fatal, but any notice violation, you have to return to go. All right. Then on the last page, you're going to list all of the relatives. It says age, but most counties will accept whether they're an adult or a minor. You don't need their specific age. I think I had one county that actually required it, not around here. I think it was down south somewhere. So we have stepmom. So this is another comment. You might want to highlight the relationship because not only do you need the person, but you need the relationship. And a lot of times people forget to put, because it's not a separate box, they forget to put the relationship. So we have stepmom who's wife, we have adult son who's son, and adult daughter who is the daughter. If you have a predeceased person, you need to put them there with their date of death, and then you would put their children. And if you had a deceased spouse, you would put the spouse's name, you would put in age, you would put deceased and the date of death, so that they know how long ago they died, the 5 or the 15-year rule. Whenever possible, date the documents for your client because they inevitably miss the date for some reason. And if you file it without the date on there, you have to go back and get it. So you sign it and your client signs it. Going back to publication on the first page for a second. So you are going to send your notice of administration to to whatever paper you're going to publish it. Here's the Contra Costa News Register. They are going to send that back to you. And it's called a proof. You need to check that proof very carefully because if they have made a significant mistake, your notice will fail. So for instance, if they check that you were admitting a will to probate and this is an intestate, your notice has failed because you have no will that you are admitting. So just be aware of that. If they get the hearing date wrong, your notice fails because you haven't provided accurate information as to when you're hearing. And they do make mistakes from time to time, so it is good to make sure you double check it. The other thing to be careful about is Contra Costa News Register files their proof of publication with the court. So they take care of that for you and then they send you the filed proof. Other newspapers do not. They send you the proof and you need to file it with the court. You need to be aware of which is which so that you don't miss filing your proof of publication and think that the newspaper has done it for you. Okay, so we are going to go on to our duties and liabilities, which is your next page in your sample forms. And this is the easiest of all of the forms to fill out. I like it because it's that easy. If you are new to probate, I suggest you read through the duties and liabilities because this tells you what your clients are responsible for and gives you an idea of what they need to do. And if you have doubts about your client being able to fulfill their duties, think twice about it because you're going to be on the hook for this. It's your name on those documents that are being filed with the court. And if you end up having to do a motion to withdraw later because they've absconded with the money, well, it's not your fault. It still doesn't look great on your record, right? So really the only thing that needs to be completed on this form is the address and telephone number. And what is commonly missed is the telephone number. So make sure you get that. And the date. For whatever reason, clients really have a hard time writing in the date. As a matter of practice, when the clients sign this, I keep one copy to file with the court and I give them one copy to take with them so that they have it right out of the gate. So then we did not do it here, but I wanted you to see the form. This is a waiver of bond form. And in this case, adult son and adult daughter were not willing to agree to waive bonds, but this is how you do it if they are. And then I like to complete my order when I'm doing all of my other probate stuff, so it's there and ready to go. And you do want to submit it to the court ahead of time so they have it and they can review it. And it basically just follows along with the petition. So the decedent died on April 1st. He was a resident of California. He died intestate. We are appointing stepmom as administrator. Oh, look at that. I forgot to check full authority. We always want full authority. So check that box, full authority. And And here I have bond at 1.5 million when we said it was 1.6, so change it to 1.6, because it needs to match, your order needs to match your petition. But you can see how easy it is to kind of make a mistake or a typographical error, so always double check your documents. And then a probate referee, so Contra Costa assigns the probate referee at the time you file your petition, and they'll put a stamp on it. We have multiple probate referees here in Contra Costa County, and they rotate them, you don't get to pick. So you will know when you file your petition who your probate referee is. Other counties do it in the order. Some counties don't even bother to tell you because there's only one in the county and they figure you know. So definitely check your local county rules for what is applicable. Then we have our letters. And this is the order is important, but the letters are what the client is going to need to eventually take to these financial institutions and show them. So we have letters of administration. We are appointing stepmom as administrator with full authority. And actually the box 3 and the box with full authority should be checked. So make that correction in your papers. And then on the other side, they are an individual and where it was executed and have them signed. So depending on your jurisdiction, when you go to court, you will take these letters with you. They are not, you can submit a copy to the court, but they're not going to give it back to you. So when you go to your hearing and you've done everything perfectly and the judge gives you your order, you're going to take letters with you to get issued. If you need a bond, you have to have the bond there. They won't issue your letters. Also, if for some reason you have not filed your duties and liabilities, you have to file that before they will issue the letters. So if you want to make a note, before you can get your letters, you need to file your bond if required, your order, and your duties and liabilities. When you do that, you want to get your certified letters, and if you need a certified order, right then and there at the window. It's easier to do it there than having to go back to the records department and get them later. So the court will stamp one stamp here, but when you get them certified, there'll be a stamp on both. Any financial institution is going to want to see original certified letters. You have to give the originals to your clients so they can take them to the various financial institutions. They rarely keep them. You also need an original for each piece of property that you are going to be selling because escrow is going to ask you for original certified letters. If the sale takes a long time, then sometimes you will have to get them recertified. Usually if they're older than 6 months, the title officer will ask for a fresh certified copy, which you can, in Contra Costa, you can get from the records department. In Alameda County, you can get them right at the window. And Solano, I am not sure about off the top of my head. Yeah.
So is it advised to have multiple original copies? Or
Depending on your state, if you have real property, absolutely. If you have one IRA account, they charge you $45 a pop for these things. So you don't want to get all willy-nilly with them if you're not going to need them. But yes, usually we represent professional fiduciaries. We usually get 3 certified letters for the professional fiduciaries. If we know we're selling multiple properties, we would get multiple. But again, which happens a lot in trust administration, there's like one account out there that didn't get into the trust. I typically will only pull one because they just need to send it to that person and they will eventually send them back. It just takes a while. All right, now we are on to our. Oh, sorry.
Another one. So if there are multiple bank institutions, do you want to get multiple letters?
No, because typically, well, as it stands right now, although we're moving in a different direction, most banks have branches that they take them into and they just fax them to their legal department. However, if it's a strict online account that doesn't have a brick and mortar place, then you might need multiple because they're going to have to send them in.
I see, so escrow requires the actual original that they keep that, so in that case, you do need multiple copies.
So they keep it for the duration of the sale. Once the documents are recorded, they actually attach it to the deed and it comes back, but it takes about 6 to 8 weeks to come back.
Okay, so in a case, like, if the person was an investor, just had huge portfolio of properties, it's
Multiple.
probably a good idea to get however many properties there are.
Although depending on when your administrator is going to sell, if they're gonna hold for a while, you may not want to get them until they're closer to selling because you don't want them to get stale in your file at 45 bucks a pop. All right, notice of petition to administer estate. So decedent's estates have a notice of hearing form. And I'm sorry, I have forgotten the form number. And you use that for a lot of different things in decedent's estates. If you're noticing any type of trust action, you use that. If you are doing, maybe we don't know, he didn't have a wife and children and there's heirs out there and there's 100 people that are claiming they are a second cousin once removed. And we don't know who is supposed to take, so we're gonna do a petition to determine heirship. That gets a notice of hearing for decedent's estate. However, when you are initiating a probate, you have to use this notice of petition to administer estate. If you use just the notice of hearing of decedent's estate, your notice is going to fail. It has to be this exact form. And on this form, you are going to put any name that poor planner went by. So he was poor planner, he was P planner, he was poor E planner, he was poor Edward planner. He had all those variations of names that he used, and that just covers you. So then we say whether or not he had a will. He did not have a will, so we do not check that box. And then we are requesting authority to administer the estate under IAEA authority, so we check box 5. You can either enter the address of the court, or you can just say same as noted above. You're always going to have your address of the court above, so that is all I ever use. It gives the person receiving this some very specific information about what they can do. It tells them who to contact if they have questions, which is generally the attorney. And then on the next page is your proof of service. So once somebody actually serves it, and obviously you would put in all of the names of the people that you served. And you serve a copy of the petition with the notice, so they get the whole thing. So you check box 5. You can either check box A or B. It really doesn't make a whole lot of difference which one. They just want to know that you took care of mailing it. And what people miss a lot is you date it twice. You date it above your signature and you date it the date mailed. So it doesn't matter when you sign it, it's the date that you mailed it. You have to have mailed it within 15 days of your notice of hearing. Again, from a practical standpoint, courts aren't setting things that quickly, although I will say Solano does. Solano sometimes sets things within 30 days. They are now doing electronic filing, but that is fairly new. So we used to have to send a courier out there. We have to wait. We'd get it back and we'd be like, oh crap, we only have 20 days. We got to get this out. So do be aware of that. Like I said, Contra Costa is setting 6 months out. You're going to have plenty of time to serve it. Alameda is strict about that 45 days. When you have a rural county, you need to be careful because the newspaper may only publish once a week or once every other week, and you have to publish it 3 times before your deadline, before your hearing. So if a rural county is setting stuff pretty quickly, you may not have enough time to publish 3 days. So just be aware of that as well. So this notice, once you've completed it, once you've served it and you've signed it, this is what you send to your publishing newspaper. And that is what they base their notice off of. Okay, so we talked about the 15-day notice. So who gets notice? So if you have a will, anybody named in the will gets noticed, but in addition to that, any heirs at law get noticed, because a fundamental aspect of the law is notice and ability to be heard. So let's say dad let's say dad did make a will and he wrote out his children and he left everything to surviving spouse. So surviving spouse is the only beneficiary in the will. She's not the only one entitled to notice. Those children are still entitled to notice. So basically anybody that would take, if the person died intestate, gets notice, even if they weren't mentioned in the will, because they have an opportunity to come to court and say, stepmom forged that will. That's not a valid will. My dad would have never signed that will. And if you don't give them that opportunity, then their rights have been lost. So be aware of that. And then again, we talked about if you have a trust, all persons named in the trust, and then you have to publish at least 15 days before the hearing, and it has to be published 3 times.
Are you liable? If you don't name all those people, they come back to you.
So you could be as an attorney liable if you knew and you didn't put them on, because that is your error. As I mentioned, clients are not always 100% truthful. So what is helpful is to make sure you take good notes about who they gave you. And if specifically, if they said, oh, I never had any brothers or sisters or whatever, then no, you're not liable. You're not expected to know their family tree. But if they give you a list of 10 people and your office failed to notice that person, then yes, you could be liable. Now, what typically happens is it doesn't get far enough down the road that you've already distributed, and then this person comes out of the woodwork. Usually it's just an embarrassing moment of a person calls your office and says, hey, I heard that my dad died and you were probating this will and I wasn't noticed. And you're like, well, who are you? I'm his son. Oh, well, okay. So it rarely gets to the point where, like I said, you've distributed, because probates are not quick. They're usually a year to 18 months. So somebody in there is going to spill the beans to this person at some point. Where it really happens a lot, I shouldn't say a lot, where it happens most frequently is there is a step sibling. So it is the biological child of the person, but not the same mother or father. And they haven't heard from the person in years, and they really kind of forgot about that person, or don't think that the person is applicable. So it is important to probe your clients a little bit, like, okay, have any stepbrothers? Well, yeah, but he doesn't count because he hasn't been around for 20. He still counts. Sorry, he still counts.
One other question, you have already mentioned this. Is all the personal property and real property locked up until probate is finalized?
Yes. There are some things that you can do for family allowance and stuff, but for the most part, yes. And that is something to really counsel your clients on. Do not distribute until you get that court order.
So that real estate could be locked up. Right?
No, sorry, you can sell it during the administration. So you can administer, you can pay debts, you can pay expenses. What you can't do is distribute the estate to the beneficiaries. So the administrator is in charge. And during COVID, that was a big problem because we had these long delays and you had these mortgages going delinquent because they couldn't free up any money to be able to pay them and stuff. So as soon as probate is open and the letters are issued, that person is in charge and they can start administering the estate. They can marshal the assets and take control. Okay. So you're going to have a hearing date. Before your hearing, you're going to want to check your tentative ruling. Make sure you make any corrections that are needed. You're going to attend the hearing and you're going to obtain your certified letters. So this talks about what the executor is charged with, and this is on your duties and liabilities. That gives you a good summary of what they need to do. If an executor breaches their duty, they can be held liable to the beneficiaries and they can have to pay back money. They can have to forfeit their fees, or they can actually have to come out of pocket if the estate was damaged. We talked a little bit about IAEA, Independent Administration of Estates Act, and this is really where it comes in handy. So what they can do without a court order is invest money. You can operate decedent's business for up to 6 months, and you can commence and you can defend litigation. And a lot of times you're opening an estate simply for the litigation purposes. Somebody has filed a suit against the decedent, maybe they were involved in something and then they die. You have to have an administrator appointed to continue that litigation. You can allow, pay, reject, or contest any creditor claim except your own administrator's creditor claim. And if you had attorney's fees that are a creditor claim, you cannot do that without court order. You can compromise or settle any claim. You can release uncollectible claims, and you can pay the taxes. So this is the main reason I like the IAEA is after providing notice, you can sell the real property. You do not need a separate court order to sell the property. With court hearings being so far out, that really comes in handy because again, our notice period is only 15 days for a probate. So we can send this notice, we can close within 15 days if nobody objects and move on. And you can do some preliminary distributions, which I never do without a court order. Even with IAEI, you do need court approval if you want to invest in securities. Probates are not intended to last. They're intended to be a final administration. We want to move to cash, get everything distributed. So if you want to invest in securities, you need a court order. If the business is going to continue more than 6 months, you need a court order. If you need to settle a claim against your personal representative, you need a court order. And if you want to pursue a wrongful death claim, you need a court order. Any compensation for your administrator, executor, or yourself, accounting, you can't just notice your accounting with a notebook and say, it looks good, doesn't it? If you don't object in 15 days, it has to be filed with the court. And if your administrator or you want to buy the property out of the estate, you need a court order. So this is really a strategy thing. If your surviving spouse comes to you and she says, I want to buy this property, you really need to weigh whether or not it makes sense for her to be the administrator or not, because she's going to have to jump through a bunch more hoops to get that property than she would if somebody else were the administrator and they sell it to her. All right, so now we've gotten our lenders, yay, probate. So one of the first things you're going to want to do is get an EIN for your estate. I don't do this until I get letters because the minute you pull that EIN, it triggers the period of time to start the tax return. And again, hearing dates being what they are, if you're not going to have a hearing date for 2 months, you don't want to lose 2 months of your administration and have to file that tax return sooner. Now surviving spouse has the EIN, she's going to go to the banks, she's going to marshal the assets. You want to tell your clients they have to get you date of death statements. He died April 1st. We need those April statements. And you want to do it when you're going to the bank to marshal the accounts. If you try to do it later, they're really hard to get. Then we're going to do our notice to creditors. You always, 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 this is one of the times in the law where always actually applies, have to notice the franchise tax board. And I provided in your packet a notice to creditors, and this is the form that you have to send them. So even if you don't have any other creditors of the estate, under all circumstances, all the time, you have to send it to the franchise tax board. And I actually gave you the address on your form, so you will have it for next time. They also want you to send a copy, not an original, a copy of the death certificate with that form to the franchise tax board so they can match it up. And they will send you something that says either he owes a boatload of taxes or we don't have any tax liability for this decedent. So you want to get this notice to creditors out as soon as possible. They have 120 days from the dates letters are issued, or 60 days from the day they get this notice. to submit their creditor claims, and you want those to start coming in, so you know the liquidity you have in your estate. And you send it to the creditors with this blank creditor claim form, so they know what they need to fill out. Then you get your inventory and appraisal going, and this is why I told you you want them to get you date of death statements. You never want to take their word for what the value was at date of death. You want to see it with your own eyes, because inevitably he happened to die on April 1st, but typically people die in the middle of any given month. And they will look at the beginning value of the statement and tell you that's what it is. Well, that's not what it is, because it literally is the exact value on the date of death. That is what needs to go into the inventory and appraisal. And when you're doing a probate for somebody who's been dead for 5 years, you still need those date of death values. So the further away you get from that date of death, the trickier it gets. So inventory and appraisals. Your administrator is going to value the stuff on Schedule 1 or Attachment 1. And the probate referee is going to value the stuff on Attachment 2. So Attachment 1 is anything that is cash. So here we have a savings account. Our savings account is cash. We have real property. Real property is not cash. That gets valued by the probate referee. And then we have the Vanguard IRA. So on Attachment 2, you will see you need to put the address and you need to put the legal description of the real property. For the IRA, you need to list all of the stocks in the IRA account painstakingly, each and every one of them, and give the symbol and how many shares each one has. If you have a big stock account, this is an undertaking, but it has to be done. You are then going to send something else that's really important on this form is when it comes back, you, as the attorney, are going to certify whether your bond is sufficient or not. So if you see statement about bond, here we have 1.6 million, and we're going to say it's sufficient because when the probate referee gets back to us, that turns out to be the value of the estate. But it is incumbent on you under the California Rules of Court. If it is not sufficient, you have a duty and an obligation to increase bond as soon as practical. So you have to go into the court ex parte and you have to increase your bond. And you as the attorney can be held liable for failure to do that. So something to be aware of.
A quick question on the appraisal of the property. Is that, so when the referee's determining it, they don't do a full like walk around set out and everything, it's like a desktop kind of appraisal, so.
It is, they look at comparables, it is very cursory and oftentimes it will not be accurate. So if the house ends up selling for what the house sells for, that's what would be used to determine statutory fees and whatever, but where it comes into play is if you need confirmation of sale. If the probate referee says, oh, this is a $3 million house, but you can only get offers for 1 million. You have to go back to that probate referee and say, look, you need to reappraise this, because on a court confirmation, it has to be 90% of the probate referee's value.
But full authority doesn't matter.
Full authority does matter because you only need to send the notice of proposed action. You don't need a confirmation. So as long as the beneficiaries are not like, well, the probate referee said it was worth 3 million. Why are you selling it for 1 million? I mean, if they fundamentally understand, okay, we haven't done any repairs to this house for 30 years, we get it's only worth 1 million, then you're fine.
Okay.
When you send this to the probate referee who is on your petition, so you know who it is, you're going to send them a cover letter explaining, you're going to send them the date of death statement for the Vanguard account so they can see the stocks that were in there. And if for some reason you have an appraisal of the property that was done independently, or if it's already on the market, because sometimes it is by the time you get all the information for your inventory appraisal, because they want to get it on the market right away. You're gonna tell them that, you're gonna help them value the assets at what you want them to. If the house is completely dilapidated, you're going to tell them that so that they don't overvalue it and get your beneficiaries all riled up that this should be a $3 million house. So any facts that you can give them that's going to help them accurately assess the value should be included in that cover letter. When you do the inventory and appraisal, you are checking off a box that says if the decedent owned real property, you have submitted a change in ownership, death of real property owner. And I have included that form here. You pull that off of the assessor's office and you send it to the assessor in which the county that the decedent has the property is. So if the decedent had a rental property in Solano, you would send one to Solano County and you would send one to Contra Costa County for the Martinez property. Okay, so now we've had the claims come in. And now we need to decide, are we going to accept them or are we going to reject them? So we've had a claim from American Express for $5,000. So you talk to your administrator. Does she think that this is legitimate? Did they really spend it? Did somebody abscond with the card and use it fraudulently? And she said, no, she said, yeah, they had been using it before he died and this is legit. So you're going to accept the claim for $5,000 and you are going to have her sign it and you are going to mail it back to the creditor. And then you are going to instruct your client to pay the creditor and you are going to file your accepted creditor claim with the court. All right, now we're ready to sell the house. Yay, house is up for sale. So we need to do a notice of proposed action and we need to tell the beneficiaries what is going on with this sale. So she has full authority to act and the date is going to be at least 15 days beyond what your mailing date is. So you are giving them the 15 days notice. And then you're going to describe the action. So here we are selling the real property for a sales price of $1 million to Sally and Fred buyer with a sales commission of 5% paid to Betty broker. So you need to tell them the commission, you need to tell them the sales price. If there's any other special terms, you want to put it in there. So here, our inventory and appraisal has come back and it was appraised at $1 million. So it's selling for exactly what we thought it would. So that's great. That never happens. This is just for sample purposes. And if you haven't had a chance to do your inventory and appraisal yet, that's okay. You just check the box that says no inventory yet. Then the next page is just a notice. We've seen these before. But at the bottom is an objection or a consent. Most of the time, beneficiaries do neither. They just ignore it. But if they object, then you have to go to court to get confirmation. If they consent, great. If they do nothing, it is deemed a consent after the 15 days passes. So escrow is going to ask you, oh, yep, go ahead.
Yeah, sorry, just on the previous page for the real property transaction, you said that you have to include, a commissioner compensation. I know it might not be very common, but the attorney is also brokering the sale of the property. Would that be included?
That would absolutely need to be disclosed, and I'm honestly not even sure you can do that without court approval because an attorney is not allowed to take any compensation from an estate without a court order.
Gotcha, okay.
So escrow is going to ask you for what's called a comfort letter. And basically it's to give them comfort that this is a legitimate transaction. And I have given you a sample of a comfort letter. And basically they want to know that the letters are still valid, that you sent the notice of proposed action like you were supposed to, and that there was no objection, and that they got at least 15 days notice, and that there's no taxes that need to be paid for the decedent's death. So when you send to escrow, you are going to send them the certified letters, the comfort letter, and there is a third thing. The notice of proposed action, sorry. So you're gonna send them the comfort letter, the notice of proposed action, and the original certified letters. All right, so now we're calculating our fees, and I know we're getting short on time, so I will try to do the best that I can, but the fees are set by statute. So we had a $1.6 million estate. We had receipts of $50,000. We had gains on sale of $150,000, and then we had losses of $100,000. You do not need to deduct your regular cost of administration. So let's say in the sale of the house, we paid off the mortgage. That doesn't count. It's a gross estate. So our gross estate is 1.6 million, and our fees are 23,000. 23,000 for the attorney and 23,000 for the administrator. All right, so the most difficult part that is not a judicial counsel form is your petition for final distribution. I have given you a sample. You cannot file this petition before 120 days has lapsed since your letters were issued. I know that I'm out of time, so what do we need to do? Do we need to tell anybody online, or can I just try to finish this up?
I think probably
can drop
15
off
more
if they want.
minutes, yeah.
Okay.
Everyone's still on, so.
All right, sorry, running a little over here. And I will stick around after, so if you have additional questions that I didn't cover, just let me know.
Cannot be filed before 120 days.
120 days from the date letters issued, because that's your creditor period. So the court's not going to accept your petition for final distribution unless they know all the creditors have been taken care of. And here they have, we only had the one creditor. If creditors don't file a claim, so even though you know they're there, so DCM services will light your phone up 100 times for your probate, but if they don't actually file their claim, too bad for them. I mean, they know what they need to do. And so you don't have to pay it. You can, but you don't have to. Here, surviving spouse did not want to pay anything she did not have to, because she was already bitter that she is not getting everything like her husband promised her. So, the petition for final distribution is an attorney drafted document on pleading paper. There are statutory requirements for what it has to have, which I have tried to include. So you need to include the date of death, when the estate was admitted to probate, whether or not there was a bond, and you have to state that all bond premiums have been paid. That is a requirement. Whether or not there was authority granted under IAEA, that you did notice the petition like you were supposed to, whether or not there was notice to public entities required. So Medi-Cal, for instance, was he a Medi-Cal recipient? If so, you needed to notify Medi-Cal. Victims Compensation Board, if your decedent was a felon and had a conviction and was confined to prison and had a judgment against him to repay victims, you have to notice the prison system. We did notice the Franchise Tax Board. So it is sometimes a bummer, and we've done it here too. We've forgotten to notice the Franchise Tax Board inadvertently. You have to go back and you have to notice them before you can close your petition. So now you're delayed again. So that is a bummer when you forget to do that, because you're waiting for that $23,000 order to come in. If anyone has requested special notice, you have to provide them notice, and you have to tell the court who requested special notice. You have to tell them that you filed an inventory and appraisal and what the value of the assets were. Here, we have to tell them whether or not the decedent had separate property or community property. So here, the estate consists of only separate property. Summary of account talks about basically on your accounting, when you do it, there's a summary page and you want to tell them what the time period that the account covers. And here, most likely, it would have been April 1st through December 31st. That's still a little aggressive to get a probate done, but we were really efficient. If there were anything in the accounting that is not clear or is could be called into question. You want to address it right up front and you want to put it here. So for instance, let's say on your loss schedule, there was a car and it had zero value. You could say that the car was in such poor condition and that to even make it sellable in the state of California, it would have cost more than the car was worth. So it ended up being donated to Cars for Kids as the best alternative. And that would be something you would want to explain in the unusual items. If you received compensation, which you are not supposed to receive compensation, you have to disclose it here, but you better have a darn good reason because you are not supposed to receive compensation. Family or affiliate relationship, if you or your client is related to anybody that was paid from the estate, you need to disclose that. Investment of cash, you're supposed to receive interest on the cash in the administration while you're doing it, except those reasonably necessary to administer the estate. So if you have $1 million sitting in a checking account earning no interest, that's not acceptable. Put 900 in some money marks, 900,000 in money market, keep 100,000 to pay the bills and do whatever. You have to talk about purchases and sales, which and what you did under the Independent Administrations Act, and that you have made a search for all creditors and that all creditors have been taken care of. And you have to tell the court if they have been paid, when the creditor claim was filed, when it was paid, and how much it was paid for. You have to assure the court that there is no taxes that are left and due and owing other than just the ordinary income taxes for filing with the estate. And you have to tell the court how much statutory compensation you think you and your administrator are entitled to. And you have to attach how you calculated that. And if they disagree with you, they will let you know. You have to tell them that the estate is ready to be closed. And you have to tell them what we have left on hand. Then you have to have a reserve. And in Contra Costa County, if you're going to have more than a $2,000 reserve, you have to provide them an explanation. And oftentimes you do need more than a $2,000 reserve. $2,000 is pretty low. But if everything is essentially done and literally all they have to do is that final tax return, that's probably enough. But here she had real property. And here in California, Proposition 19 passed. She is going to get a supplemental property tax bill from the date of death to the date of sale that she needs to pay. And $2,000 is not likely going to be enough to cover that. So be very, very careful with the sale of real property. And if they haven't paid that supplemental property tax by the time you're ready to close the estate, up that reserve. Then you have to tell the court, how are we distributing, the court and the beneficiaries, and give them an opportunity to object and say, well, that's not fair. I'm supposed to get something. And then you do your prayer and you tell them exactly how much you're going to give. You sign it, your client reviews it and she signs it, and you file it with the court and you wait to get your order for distribution. And once you have your order for distribution, then the client can pay you and the client can pay herself, and the client needs to send all of the checks that she promised to send, and you need to get the beneficiaries to sign a receipt to file with the court, because you need to file those receipts in order to release your bond. And if you have a reserve, you can reduce your bond down to 20,000, and then once the reserve is distributed, you can release your bond all together. So that is basically probate in a nutshell. Can I get a yay probate?
Yeah.
Awesome. I will stick around. I am sorry that we ran over. If you have questions, please let me know. Happy to answer them. If there's any questions online before people want to leave, happy to answer those now. And thank you all for attending.
Good job, Tracy.
Very formal. 23,000 all that work. Based on what it says. If it's 200 pounds, which is over there. And limit.
So if we ever had
You're only gonna get one eighth. It seemed like very. It's a lot.
Yeah, I mean, there are situations,
Go back.
I mean, there are, there could have been just behind it, and we have had it. Because pretty easy for us. We don't have somebody who is a lot of the number we're going to rate. We can even take. But if we were in a conference here, you can file a petition for extraordinary places, but it has to really be something that, like, if you have a huge tax liability that we found out from the credit and had to work with the IRS to negotiation tax court, that's when we need to petition of extraordinary for. But there are circumstances where that happens, but that's why you really want to know what the value of your estate is and whether the spouse is paying for the per share. She can take a third out of this right off the bat, and that's going to really reduce the amount that you're going to see is probably.
Finally, on the 185 or 184.5. Does that ever go to the court that decision that the state, or is that just made simply?
Not on personal property, on real property, there is a procedure to value the property.
It's just for all property. They come in, so you don't need to. Thank you very much. Thank you. I'm Patrick Feeney. I will see you next Thursday. Take all through.
Great.
I was like,
I think you're
All right, oh my guys, I'm gonna shut down this soon. Thank you guys for coming. Have a good rest of your day. Hopefully we'll see you next Wednesday.
Will. Stop. So I'm ready to look back and see what we're going to do. Thank you. Thanks for the call. Couple questions. How do you handle it?